self-durized paper governing the interface between natural formal language and smart contracts. So I think, just very briefly, we'll allow each panelist to introduce themselves, and then we'll begin with Josh, and he'll lay out sort of some of the main claims of the paper, and then we will turn it over to Brian and Gillian to offer remarks, and then from there we move to sort of more organic discussion. So, Josh, why don't you kick it off?
Sure, I'll just introduce myself. We'll run down. I'm Josh Fairfield. I'm the voting debate and panel professor of law at WNO University School of Law. I've been writing on online environments, virtual communities, and the various ways in which we structure private law in online environments for nearly 20 years now. My co-author, Niloufer Salvadori, who I hope will be joining us remotely, is at Macquarie University in Australia, and she's an expert on cyber law and on private law from the jurisdictions that I'm less familiar with. And so you can assume that anything I say that's wrong, actually, she has correct, and try to adequately represent both points of view here.
Hi, everyone. I'm Jillian Hadfield. I'm a professor of law and strategic management at the University of Toronto and director of the Schwartz-Reisman Institute for Technology and Society at UC. I've been writing for quite some time on thinking about innovative approaches to legal design and what I call legal infrastructure, making the claim in particular that our existing legal infrastructure is just poorly adapted to many features of technological society, digital, globalized world. Done a lot of work on contracts historically, not so much on smart contracts, but I'm glad to have a chance to talk them through. But thinking in particular about contracts as a sort of as a starting point for thinking about the private production of law, competitive production of law. How do we do that in ways that achieve our legitimacy goals? And I'm now spending most of my time on AI governance.
I'm Brian Slocum. I'm a professor of law at the University of the Pacific, George School of Law. I have a PhD in linguistics, and my research focuses on language and law, especially empirical approaches. Right now, I'm co-author I work with, Kevin Tobias at Georgetown University, where we focus on how ordinary people interpret language and rules. Our focus is on statutory interpretation. So we haven't come close to smart contracts, although it's an intriguing area. And hopefully shed some light on it today. But yeah, so language and law, how ordinary people think about what law communicates to ordinary people, and how that can translate to interpretable.
Great, Josh, take it away.
I don't know if this does anything, but I'll just speak up. All right, so sometimes papers reveal by kind of capturing something pithy, and sometimes they reveal something by struggling with it. I think this is a little bit the latter kind of scenario. I want to give you some clean examples of the phenomenon that I'm talking about, and then maybe try to put it in historical context. And since studies show that people will stop listening to a single person talking after about 7 minutes, I'll try to give you everything you need at the beginning through clear examples, and that way we can have a productive conversation. A couple of months ago, a owner of a non-fungible token put it online and mistyped the price. He put in I believe it was $300 rather than $300,000. Maybe it was $3,000 rather than $300,000. That he put it up in an automated system, and it was immediately bid sniped by a smart contract that was sort of roving the internet looking for undervalued assets. In talking about it, there was I'll just use the word masochism involved in his own description of the event, saying, I chose to contract through these systems. I guess this is just what happens when you contract through a decentralized, automated contracting apparatus. Another case. This is one that I've been involved with, although not in any respect that I'm talking about today. There was a cryptocurrency that had a bug in the code. The cryptocurrency was intended to reward people who staked their currency by voting for people who would responsibly develop the currency. Through the bug, someone was able to, and I'm picking my words carefully, was able to generate much more currency in a way that no one had anticipated. Their argument was they should be able to keep all of that currency because the code did it. The code let it happen, regardless of the fact that everyone involved, top to bottom, including the person who found this bug and used this bug, did not think that that's how things were going to go. A third example and a fourth example, because they keep coming. Years ago, the first DAO, the DAO was a distributed autonomous organization. It was gathering cryptocurrency, using it to develop projects. It was supposed to return money to its investors. Because of an interaction with other smart contracts, emergent properties of the code happened such that nobody knew this was possible, and yet the original DAO got drained of a huge amount of its money in a way that, again, none of the people involved thought was going to happen. Nobody intended this to happen. And there was, again, this strange sort of masochism among a certain number of people saying, well, this is just what these systems do. Conversely, however, the community came together and said, this was not what we intended. Therefore, they hard forked the currency, they set it back. And we see this again and again. There's a recent example from this year. Somebody's NFTs were stolen on the digital marketplace, OpenSea. And did people sit there and say, oh, it was the code did it, therefore it is what we intended? No, they went to the intermediaries and they said, fix this, block these assets from moving through the code. Let's set this in terms of what I'm worried about. What I'm worried about is at what point in the interaction between natural language, what we're using, and code, does the contractual magic happen? If you and I shake hands over a deal, that's when it happens. If I click I accept to an Amazon server, that's when it happens, question mark, and I'm just going to keep adding question marks. When my smart contract interacts with your smart contract, that's when it happens, question mark, question mark. At what point do we begin to wrap code? Do we begin to wrap contracts in code or code in contracts in a way that, and I'll just give you a brief example, and then I'm going to sort of lay down the foundation of what I'm talking about and be done. At what point do we recognize that there's a problem with where we locate the contractual magic? That if it gets far enough away from humans, we begin to become concerned about the question, what did people intend? And about the necessary feature, especially of decentralized smart contracting systems, that because they are decentralized, they interact with other code in ways that is not controlled by any particular human. My kid brother, who's the lead engineer on the Waymo Google Cars project, one time for one of his Google sabbaticals, cooked up this thing that he was going to turn loose on the internet, and all it did was rent space on Amazon web servers and then try to earn cryptocurrency so they could serve cat videos. So just serve cat videos or whatever, get cryptocurrency, use that to rent itself server space and kind of spread that way. At what point in this process of moving step by step further and further away from humans do we want to locate the contractual magic? Because at some point, from a recent case, Renzel versus Centratech, at some point it escapes us. That case simply said, people who buy cryptocurrency through a website, the contractual magic happened. They said, when you hit the landing page of the website. That is itself an attenuated view of consent. That's a problem. But that's when the contractual magic happened. Therefore, those people lost their right to go to court under a mandatory arbitration provision. Whereas the people who directly bought the cryptocurrency through a smart contract, they did not, because there was no human who encountered legal terms. The reason that this is, for me, a problem of enormous interest is that there is a disconnect between the way that I am talking to you now, where I am gradually negotiating the meaning of words between us, and so are you when you talk to me, and the way that formal computer languages work, which is largely in the way of a mechanical process. You can create a Turing-complete machine out of rocks if you have to. It's a purely mechanical process instantiating certain logical operations. What I want to say is this. Contract law is about satisfying human preference. Yes, humans can decide to contract with each other via technological media to communicate their preference. And even as we go one step further, humans can decide to communicate with each other via an automated execution process, like my getting gas this morning. I go to a gas pump and I pump gas. We're using a machine to contract between me and the corporation that sells the gas. That's automated execution. But what we do, and we can even get to the point of saying the structure of the machine, the structure of the automatic execution, can reveal something to us about what we thought the deal was. But what it cannot do is it cannot be the deal. Paper sets out reasons why code cannot, for reasons of math and computer science that I'm happy to get into, but I think we'll skip here. We'll just say code cannot be bug-free. It cannot, we know it. That's Gödel's incompleteness theorem. That's why we do not have bug checking software that will catch all bugs. It's called the halting problem. We cannot find the bugs in code other than running the code. And when we've got decentralized code running with other decentralized code, bugs will emerge and we're not going to catch them. What that means is that although we can look at code and say, oh, this looks like what people intended, when it does something radically other than that, a court ought to feel free to say, no, this is not what the contract was. A court ought to say, look, this is basic Scrivener's error. You knew perfectly well that NFT was worth $300,000, not $3,000. You sniped it, give it back. You should know perfectly well that the parties never intended for somebody to be able to hack the cryptocurrency, generate millions and millions of dollars of currency that was never intended to be issued, and then keep it simply because that's what the code does. That's my argument. We should not be able to drain the assets of the DAO and say, okay, the code let me do that, when it clearly contravened what everyone involved thought was going on here. Now, are there complications to this? Absolutely. There are. But as a basic principle, I want to stand strongly. This piece, I hope, will raise the point that we do not want to have the idea that the code is the contract is simply not true. The contract is the understanding of the humans involved. The code is a method of executing it. The code can give us clues to human intention, but it cannot express that intention because we can show that it will always do and can always do something radically different from what the humans intended. That's where I'm going to leave it and let my co-panelists have at it and tear it.
Yeah, Jillian, why don't you respond?
Okay, there's.
I don't think it works.
Yeah, okay. It might be. It's working for the Zoom.
Yeah, it could be.
There's so many directions to go in thinking about these ideas that Josh was putting forward for us here. And I'm just going to pick a couple. So I've been thinking about incomplete contracting. Sorry, not close enough. I've been thinking about incomplete contracting since PhD dissertation, which is way long ago. And so the claim that code can't ever be subcontract, I think we can also say about natural language. The contract, the expression of the contract is not the contract, right? It's evidence of the intent of the parties. And what we have are sets of institutions. This is coming back to the point I was making in our earlier panels. We have a set of well-developed institutions that come in to fill in when that mechanism of expressing our intentions in natural language has failed. When we said, I'll deliver a pound of peas for $100 next Tuesday, and I said nothing else, but it was like, oh, no, pandemic. I didn't promise to do it if everything shut down. Or hurricane, I didn't promise to do it if the road is inaccessible. And we have courts that are willing to do that. And a number of the examples that Josh is giving about, like a Scrivener's error or mistake, all of our doctrines of contract law are about the way that institution works to fill in those gaps and correct for that problem. So I want to sort of emphasize, yes, the fact that code is also going to not be a representation of intent. That's kind of the entire body of contract law. The question is, what are the right institutions for that? And I want to think about this really from a design perspective, rather than how do we align smart contracts and the institutions, meaning the actual processes as well as the rules we apply in those processes, the way they operate, that rather than saying, how do we align our, you should be able to get the same result when you contract using this computer mechanism as when you use the natural language mechanism. That's not clear to me that that's the right starting point. And so I want to push back a little bit on the idea it's just masochistic to say, well, that's what you get when you agree to participate in the system, that if you forget the zeros, that's what you get a deal you never intended, which also happens a ton in natural language, of course. And to say, no, the question I want to ask is that what's the right design for that system? And I think one of the things we haven't yet seen in the area of smart contracts, actually, I was on the advisory board for a small company that was trying to do something about this, which is, and you mentioned this a little bit in the paper, Josh, the development of the dispute the digital dispute resolution mechanisms that can, so what they had was they just had a one line of code that you inserted into your smart contract that if somebody challenged a deal, soon enough, it would kick it over and hold execution in abeyance until it had a dispute resolution through a provider that was on this platform. They didn't provide dispute resolution, they just provided the platform for dispute resolution providers, private dispute resolution providers. So the point being that I think it can make absolute sense to say, this is what you get if you choose to contract in this way. You get the package of dispute resolution, gap filling, responding to the incompleteness problem that you've chosen, right? And that's what happens when people choose jurisdictions in contract law. They want New York law, they want California law, they want UNTITLE, they want, they want some other body of law to do this, they want a private arbitrator to do this. So I think I wouldn't begin at the starting point of, this doesn't look like it does in our natural language mechanism. How can we align it, or rather, what's the right design for the smart contract? I have lots of other things to talk about, but I'll leave it there for now.
So maybe I could intersect with what Jillian is saying. Ideally, hopefully, be taken that way. And hopefully this won't be too abstract. But I think the overall theme is intention, right? How do we figure out the intention of people? And so it's often the case with new technology, it causes us to think about what we thought we already knew, right? Like I work with statutory interpretation. There's new empirical ways to figure out how people use language, like corpus linguistics, which has caused people to think about how we interpret without corpus linguistics and how we think we know what words mean. And so how do we think we know what people mean when they do something? And every kind of communication is a combination of maybe real intentions and constructed intentions. But there's always some constructive intention. And just think about the paragon of contractual formations, right? You have an oral conversation, you have offer, you have acceptance, you have negotiation, and maybe it's face-to-face. But think about, even within that scenario, there's constructed intentions. And it's understood, not just in law, but in just how people interact, that there might well be a gap between expressions and intentions, right? And expressions are more important than intentions, right? Not just in law, but in language generally. In the sense that you don't get to decide what your words mean, right? There's a community. We try to figure out what someone means when they use words, but that only goes so far. There are limits, right? People can't convince you that the words mean anything they want them to mean, there are limits. And so with intention, not every contract has this paragon, right? Even so, we have oral kind of communication at one side, and maybe contract or smart contracts on the very other side. But I agree with Josh, even with smart contracts, you can translate what's going on into natural language, right? But if we're thinking about how you can do that, it's probably going to look very kind of constructed, right? It's in the same way that, think about a form contract, right? A contract of adhesion. In what sense does that really represent the intentions of, say, the consumer? It all has to be kind of constructed, right? And in the sense of a reasonable person, an ordinary person. Is it the ordinary customer, how they would interpret those terms, whether they actually read them or not? But it's often kind of constructed on both sides, right? You go into a store and you sign a contract with the other party that the other party probably has not complete knowledge of, and the form contract doesn't represent the actual intentions of that person, right? It could be they got language from somewhere else. And so kind of on both sides, there's this kind of constructed intent. And so I think it's very coherent to talk about intention and to talk about natural language when we're thinking about smart contracts. We just have to be aware of what we mean and what kind of intentions we're trying to capture. And they probably aren't going to look very close to what we think we're doing when we talk to someone face to face, right? And even that, there's a lot of constructive intention. But there's also, when you talk to someone face to face, there's a lot of inferences that you make based on nonverbal cues, based on a history with the speaker, where you're making inferences about what you think the person is trying to communicate that probably aren't possible at all with smart contracts.
That's fantastic. I want to start sort of with like a systems-wide question. So sort of building on some of Jillian's work about like the private competitive production of law, can like the system of smart contracts offer a sort of distinct set of contracting to act as sort of like a competitive pressure on contract law itself? And Josh, I was rereading your 2014 paper, Smart Contracts, Putting Great Thoughts in Consumer Protection, where like, as I understand you, there's like a little bit of optimism. So like, as I understand the main argument, is that the law of consumer contracting has been interpreted in ways that are incredibly favorable to firms and very harsh towards consumers. So we have this thing called smart contracts where we can sort of offer our own new rules of contracting and have an automated execution process that can supplant traditional contract law that's been very hostile to consumer interests. So I wonder if maybe you two have sort of like a natural disagreement about the extent to which smart contracting could be sort of this alternative mechanism, whether it's viable, is it legitimate, and what sorts of institutions will we need? And then building from there, we can move to some of like the interpretive questions. But I see this as a potential point of disagreement, so I just want to kind of hit it first.
Let's try it. Yeah, and maybe I'll push Josh to try and make sure we end up in disagreement. Yeah, so when I was writing about competitive production of law, and as an economist, I'm thinking, okay, so it was really a critique of the way our legal systems have evolved, which is they're quite closed systems. They're incredibly closed systems, and they're not under a lot of pressure to produce rules that are well balanced in terms of cost benefit and so on. And so this is something I started writing about many years ago. And I started to ask the question, well, why is contract law, for example, why is that a state product? Why is that something that's produced through state institutions? Why is it not produced through private production? And which is totally independent, because totally independent of whether you can regulate the contract. You can absolutely regulate the contract from the outside, but in terms of just the private obligations, is this what we meant? What are the rules we want to implement our agreement? And part of the critique was to say, okay, what are our doctrines of contract law? Things like impossibility, mistake, a number of things you mentioned in the paper, Josh, that you know, they are the consequence of that process. And they're not necessarily the optimal set of rules for all circumstances. And there may very well be individuals, companies, someone who would prefer to contract with a different set of rules. Like they say, okay, you get half an hour with an arbitrator, and that's it to argue when you have a dispute. You don't get, you know, 3 months of litigation. You might see that's something that would emerge from that. So I do think that I want to think about smart contracts as being able to potentially provide us with a set of institutions that say, no, we want to choose to participate in a different kind of enforcement regime. Ideally, there's also a variety of those enforcement regimes for smart contracts. We may decide we need to regulate it at some point and say, actually, you can't offer a smart contract unless you have provided following features for dispute resolution or some features for dispute resolution. But I think I'd like to see us moving away from the singular model of, and honestly, you're thinking about Anglo common law contracts, right? We don't even have the implied good faith provision in Canada, by the way, which I was a big surprise when I went back to Canada, started teaching contract law. There's, you know, there are different models, and we should have, you know, so let's open up the capacity for creativity and design around enforcement.
So a number of themes here. First of all, with respect to the idea that these are functionally equivalent, therefore, and I don't know that that's exactly what's being said here, but I think I'm hearing that one puts pressure on the other rather than that they are equivalent. But I think that, among other things, a force majeure clause or a commercial impracticability clause does show that there's something different about natural and formal language. You can't code a commercial impracticability clause. What it says is the occurrence of a condition, the non-occurrence of which was a basic assumption of the parties to the contract, causes it to call off. Now, the argument here is maybe that's a suboptimal rule, and maybe we can have an enforcement regime that goes a different way. What I want to point out is we can't code that rule because you can't code something that you can't think of. These are positive statements. You're going to have to kick that out to some natural language adjudicator. Another way of putting it is, I was at a conference in Melbourne where somebody was talking about, we've automated all of our traffic stops in our city. I said, cool. So when my third child was born, I was driving through many traffic lights at a terrific speed. And if I'd been pulled over at that point, how would your system deal with that? And they said, well, we would have to go ask a human. We'd have to go ask a judge and arbitrator. That's the point. You can't deal with cases that have not been previously specified through code. You have to go to some kind of natural system. And that goes to then this question of, fine, what we're dealing with here is the question of choice of gap fillers for incomplete contracts. How do we deal with the inevitable gap of me speeding in that event? And there I do want to challenge this idea that there is a choice, because it's not a choice that I think most of us have experienced. When we go online, we have one framework right now, which is that we go to arbitration. And that's because the online contracts involved have chosen that within the US framework for reasons of eliminating class actions. Now, those are other market pressures, and they have indeed decided that removing most legal protections from consumers is more efficient for some actors in the market. But I'm not convinced that that constitutes the kind of choice of gap fillers that we ought to be pushing forward here. Now, in some contexts, I agree completely. I think that, for example, in the kind of commercial arbitration situations between commercial entities, these sorts of provisions may well provide a really useful, speedy mechanism for settling those things. For example, banks seem to really love the idea of a permissioned blockchain among them for things like check settlement. Having a record of settlement that nobody can alter, just the fact that nobody can change the deposits, really helps them. That I think is a solid use of the technology. But I really do think that this idea here, where we are talking about, oh, we should be able to choose what gap filler we have, That's why I keep bringing up this Renzel versus Centratech case. Literally, the people who went through one contracting with a machine mechanism lost their ability to go to court. And I'll have one further thing to say about the Anglo common law system. The people who went the other way did not. That's a heck of a difference. And if that should be an intentional difference, and maybe even one that we want to further explicate. Finally, I'll admit, I do think that technology law should progress as a matter of public record, incrementally and experimentally. And I think that the common law system does a reasonably good job of that. Although I think the civil systems, for example, they've developed the GDPR and we've done nothing in 25 years on privacy. So I'm not going to say that the common law system is fundamentally controlled. As to Anglo, the hope would be that the Anglo system, that the common law system can accept different inputs. For example, I'll be going to New Zealand this summer and looking at other narratives that we can use to plug into this common law iterative system. We choose the legal fiction of a firm as the legal narrative way of organizing ourselves. There are other ways. We can choose the legal fiction of a river to organize human and non-human interests more equitably, for example. So I think the problem with the Anglo part of the Anglo common law system is when it restricts its inputs, but otherwise, I'm a big fan of ingesting new narratives, getting new narratives for how we ought to see this process for what we think is fair, letting courts decide on that as a matter of public record and binding going forward. And I have real questions about the degree to which there is a choice involved, or there will be a choice involved, and the degree to which that's going to help people who are on the narrow end of the power stick with respect to these transactions.
That's a quick comment. I would say we already only have a partially common law system. So if you teach contract law, students have all sorts of questions. And you have to tell them, well, you should take a consumer law class because you're going to learn about statutes and how they change the common law. Or you have to take employment law, labor law, all sorts of other classes. So this idea that something kind of fundamentally would have to change in order to kind of displace the common law for smart contracts, I think is, I don't know, but I think probably the present system can accommodate smart contracts, I'd imagine, with a combination of common law rules and statutory fixes. And I think incomplete contracts, of course you can have gap fillers, and you can assume that whatever the smart contract says, that there are gap fillers, right? And just the question is, what is a gap filler supposed to represent? Is it supposed to represent kind of a penalty default against the people who write the smart contracts? One way to handle it. Is it supposed to represent how ordinary people think, what they think about smart contracts, what they think they're getting into, what they think would be a fair regime? Is it supposed to represent not just all ordinary people, but is there some subset of ordinary people that are going to enter into smart contracts? Maybe smart contracts have grown so much that they're the group of people who are entering into smart contracts, that's just a representative of the population generally. Yeah, I think of course there's a way to bring smart contracts into kind of the world of regular contract law without changing anything too fundamental.
Great. So I see like a bunch of different ideas on the board, and like the main sort of, I'm going to try to summarize some of these arguments in my words, but I think, Jillian sort of leaving the door open for a competitive system where, maybe the common law approach is best. We can have different competing regimes and people can opt into the set of contract rules that they find most desirable and optimal. And Josh, on the other hand, is kind of saying, well, maybe people don't really have a choice. Maybe Amazon will force me to contract in the smart contracting system that has rules most favorable to Amazon. And because I don't have that much bargaining power, I'll be forced to accept some set of rules that might be personally sublime. Jillian, I sort of want to turn to you and say, do you have sort of a response? Like, does the unequal field of bargaining power sort of push in one way or another about the possibility of having competitive systems of contract law?
Yeah, so we don't want to conflate the problems of consent, which are rife online in particular. And we talked about this in our previous sessions. I mean, it's a lovely phrase from Lord Denny, I believe. It's farce and fiction. This is from the standardized contracts, the ticket cases, right? That this is just a farce and a fiction of consent, and model, a theoretical model of contract. And I think we're in a terrible state right now because tons of our legal environment of online interactions, with digital interactions, which is now everything, is being governed by contracts that are not contracts, and we are lending enforcement. So I'm totally with everybody on the point that let's not get starry-eyed about consent. Let's not. There's a lot that's hard to understand here. That's a problem to deal with via regulation, and I do actually think we're going to need legal environments for smart contracts, and I actually think we should be thinking deliberately about how to build those, precisely because they don't fit well with the protective, and when I contract with the mechanism of natural language, I am contracting into a well-developed system. Now, I'm contracting one that's far too expensive for the vast majority of people. It's, again, farce and fiction. If you did understand what you agreed to, and there was a problem in that contract, you go to that expensive system to force it. I think that's where how can we start to get innovation in our dispute resolution systems that address that problem? That we need that for the natural language system as well. But if I think about smart contracts, I want to say, okay, so we might want to regulate, absolutely, who can enter into a smart contract, who can offer a smart contract. We again, licensors could have the capacity to say, you can't offer that thing on the web without a dispute resolution mechanism, without the line of code that allows you to freeze execution pending some dispute resolution process, which could look like lots of things. Conventional litigation, it could look like a democratic, let's go to an online jury to decide, it could be all kinds of things. So I don't want to conflate the idea that it can be a good thing to have diversity, innovation, and that's really the diversity point. It's not for pure competition, it's the innovation point. What do we get out of that competition? It's innovation and new ways of resolving and better ways of resolving our disputes. So my 2 points, I think we need specialized institutions, but we should allow the emergence of specialized institutions. We may need to trigger that, foster that regulation for smart contracts. We shouldn't conflate our consent problem into, we need recourse to our existing institutions because absolutely we have consent problems all over the place in the world. Okay, separately to us.
Okay. Cool. So I think we've now maybe reached the point of principal disagreement. We can kind of lay it out and talk about it. I absolutely agree that consent's a farce and a fiction online. And I think that this is the problems that we're talking about, in my view, are an extension of it, saying essentially, when I engage in a transaction that's not just using technology to transfer my intention, right, to carry the terms of the contract, but when I'm engaging in something where the most accurate description is somehow what I intend is partially carried out by this system, and my intentions are maybe even shaped by the system, then I do think that we're asking, as we asked in Rensselaer, how deep into code does the law apply my intention? It's kind of an extended version of the consent problem. Let's imagine somebody wraps an arbitration agreement deep in the code of a smart contract. The court, it is in some ways a cousin of this initial problem, which is why I started my problem with these series of question marks. You and I shake hands, clearly contract. I shake hands with an Amazon server, contract question mark. Our smart contracts shake hands with each other, question mark. Like as it gets further and further, the question of how serious we take the idea that I in any way am the source of law, that my agreement, my involvement with this process generates access to the legal system, to a legal process, I think becomes just more and more attenuated until we reach this question of what happens when there's legal language buried deep in smart contracts, or what happens when a smart contract does something that completely contravenes the terms of either express or implied actual contract. Do we need specialized institutions for smart contracts? We really might. We really might. There are features of smart contracts as an execution mechanism. Smart contracts, I maintain, are neither smart nor contracts. That's not, I didn't come up with that. That's been the state of the literature for ages on this. But for example, their indelibility, their immutability might require some special thinking. The idea that once you move the thing in a decentralized blockchain, the token or whatever, you can't move it back. A court can't just simply say, move it back. They've got to be able to reach the people involved. There will be some need for some new approaches and institutions. But I'm going to go off of the prior statement, which is I think that first we need to have courts iterate our narrative, say what it is that we're doing here, put legal decisions out that can serve as the basis for the development of further law, or find legislative discussion if you want to go that route. Also, legislative interpretation, you want to go that route, that's fine. These are all iterative, natural language processes where we talk about what the mechanisms ought to be, and we can use that as the basis for future decisions. So if we need specialized institutions for smart contracts, like the real difficulty in giving something back, in undoing a transaction on an immutable blockchain, we might need that, but we need to talk first and develop a set of shared norms and goals about what it means to engage in this process. And the second bit here that I've said already, I do think that the consent problem, that this is an extension of the consent problem. I'll give an example. Many blockchain organizations are now really struggling because they were relying on using the end user license agreement centralized control model, where everybody has to click I agree and then is bound by IP terms and conditions in order to regulate the online community. That's how the bulk of the internet is actually regulated, through the Facebook terms of service, for example. But they're having trouble with that because people are instead buying tokens and they've never clicked on anything, they've never agreed. The foundations have these central constitutional contracts like the Facebook terms of service, but people haven't clicked on them, they haven't agreed to them. The contractual model seems to kind of come apart at that point. That's why we're pushing now this notion of consent to its utmost. I was at a conference last week where people finally said, look, we're done with consent. It's just now going to be notice. Notice of choice, we're done now. Just, I'm telling you the way it's going to be, and so that's the way it's going to be. That is a further extension of this, fallacy in place.
Oh, it's kind of a quick question. Why can't we, so let's say a smart contract, they are able to write code so that there's an arbitration clause. I'm still not clear why we can't treat that arbitration clause the way we would treat an arbitration clause in a form contract. So is it that, which I'm perfectly willing to agree, is it that we don't like our framework, our rules of law, our current rules of law of how we treat form contracts? But if that's the case, then we should change our rules for form contracts and then apply those to smart contracts. It's just my ignorance. I'm not sure why there's a fundamental distinction between a form contract and a smart contract as far as the intent of the non-drafting party. Is it because in a smart contract, there's just this community of users that assume that the non-drafting party to the smart contract is just the norms are such that you are assumed to agree to everything in a way that a consumer doesn't agree to everything in a standard contract, or just is the language community so different? Because if it's not, then I don't understand what the problem is.
Okay, this is cool. Here's the difficulty. It's a little bit odd already that when I talk to an Amazon server, the Amazon server wins. Even if there's like a text box for me to input my own views of the contract and strike certain clauses and whatever, the architecture has been very carefully mapped so that no terms that I enter are seen by a human. In our present contracting regime, what that means is in order to impose an arbitration clause on a human, there's a particular vulnerability. When a human sees an arbitration clause, they lose their legal rights. When a computer sees it, no human has seen it, therefore it doesn't. And so humans are superior, computers are superior contracting entities. The legal term for that is bullshit. The problem that I'm working on in the smart contract space is, what happens if we really lay bare this inconsistency? And I've got a smart contract that is going to look to buy NFTs, and you've got a smart contract to sell NFTs. And my contract sees your contract, and they exchange cryptocurrency, and I get the token in my wallet. And then you claim because you're a company, you embedded arbitration terms somewhere in that structure. This is currently what's being built. This is actually right now, after some of the cases that I've discussed, this is actually being built. And I wonder, how far are we going to push this concept that now by choosing to buy through software, I have agreed to the terms proffered by other software. At some point, it feels to me like this concept of no matter what happens, the person who is giving up their legal rights kind of loses. I'm using arbitration as one that obviously I've got an axe to grind. Like, clearly, I want to make that open up. And to the extent that if you ask me, do I think we ought to reform our view of the Federal Arbitration Act? Great. But what I'm really using is arbitration as the fighting legal right, the token that everybody's interested in, to show how the shift in underlying conceptions of what happens when human intent at some abstraction encounters computer proffered terms in a centralized or in a decentralized environment. What law results from that? It's a dramatic difference. So I think that's why the example is well worth using. So my specific answer to the question is, it does occur to me, what happens when a smart contract meets a smart contract in the wild, and both of them are offering terms? That was the source of the optimism of the 2014 article. I thought maybe, finally, a consumer would be able to offer terms that would be taken seriously by a court of law. I doubt that that will be the case, given this sort of masochistic direction that I've described in interpreting these contracts. But that would be the difference.
Can that be handled in a battle of the forms?
I'm a commercial lawyer, and that's what I wrote in the 2014 piece. But unfortunately, the battle of the forms has been, after Proceedee versus Eisenberg and Hill versus Gateway, has largely been written out of our, like my commercial law cases in those books usually stop around 2008. And we don't get further law here developed. Going to the points about we need this conversation to happen in the courts to set the basis for this is my personal opinion. There's a difference of opinion.
Great. Jillian, do you want to jump in?
Sure. So I'm just feeling a little confused, Josh, about how you're using the concept of smart contracts. A lot of things you're pointing to are automated contracting, but it's a natural language, even to say an arbitration provision, right? That would be, and as you point out, a lot of this it's the terms of service that are being written by these large providers, and you've got no choice except to click. There's no point reading it. Nobody does. There's no point reading it. There's tons of stuff that's buried in there. You were talking about a smart contract meeting another smart contract. Isn't that the contract is the contract as opposed to an agency of some kind, like a computerized agency. So I guess you're using the language of smart contract to include an entity, digital entity that's offering contract terms, which is not the way I sort of understood what we're thinking about with smart contract. That would be digitized actors on the internet behavior, and there are a lot of questions there about how we would handle that. But I think you're just reinforcing the point that you need specialized institutions, that we need to start thinking about how we're going to handle contracting by artificial entities, and how that relates to interaction with humans. And if I could maybe just make one comment back to intentions, and I think Joshua talked about, the point here is to reflect human intentions. And say, well, that is a particular view of contracting. It's not, we had historically, we've had sometimes very formal systems of contract. Like, I don't care what you intend. If you broke the stick in this way, you can drop the clod of earth. You were in this contract, which had this structure set by the state, and it wasn't about your intentions. You might even be coerced into it. Marriage contracts, for example, right? That nobody cared what your intentions were. Did you engage in these formal symbols that had these particular legal consequences attached to them? So I guess so maybe I want to just clarify when you say a smart contract means a smart contract. Can we refer to that as an artificial contracting entity? And we need to have rules about how artificial entities enter the contract.
Yeah, I mean, I think this really goes to our discussion about natural language and meaning. So what we're talking about are two different communities who use the word smart contract in different ways. And they each, I think, have some disconnects, perhaps, with how the other community uses it. So what a smart contract, in fact, is a software program, is a series of instructions written in code on a decentralized blockchain. It's a database not maintained by any one person or by a series of people. It is a distributed computer. And these are a series of instructions written by a distributed computer. An easy smart contract might be, I give you 100 blank, blank is our cryptocurrency, and then you return to me 21 blank per month for a period of time. So just be an investment kind of contract. That's a simple one because it's automated, it's completely handled over the chain. The kind of smart contract that I'm using most of the time for my own thinking is the purchase of cryptocurrency, either with fiat currency or other cryptocurrencies. So usually I will use Ether to buy ICX, for example. That will be that exchange. And that happens when one computer program recognizes another computer program and executes. Now, you might ask then, why don't we just use this other better term, automated agent? The answer is, from a legal perspective, we absolutely should. That's the point of this piece. Lawyers need to stop letting technologists call this a smart contract. Because the contract term to us means something profoundly different, means some flavor of arrangement between humans. Now, I will say, I do want the point of the piece and its express, the normative focus of the piece, and I want to own it, is to say contract law should remain human-centered for the satisfaction of human preferences, the maximization of human capabilities and welfare. There might be other goals. I don't share them. That's the normative pre-commitment I've got going on here. Contract law should reflect and satisfy human preferences. That's what contract law, that's why it's good from my perspective. It helps humans satisfy their preferences. There might be other goals. But the disconnect between technologists who use the word smart contract and what they think they're doing is engaging in behavior that a lawyer would recognize as contractual, and they're not. And lawyers using the term smart contract, and they think that what's happening is something with contract at all. And my view is that they're not. That dissociating that has been the point of the literature for quite some time, and it's such an unfortunate terminology. I wish we could say something like digital automated agent and get rid of the terminology altogether. So I endorse that shift wholeheartedly. The problem is that there's way too much sexy conversation going on about smart contracts, way too much excitement, way too much of an idea that what's going to happen is this will replace law. And the response is no, it won't replace law any more than we replaced law during the Napster revolution, during any number of these other claims that technology was going to replace the legal regime, including the most recent one, we would replace financial institutions through cryptocurrency. The answer to that is just no. But I think those series of claims that law will wither away in the face of technology are maintained on the techno side of things. And that's what is a source of this confusion. I don't think the term's a good one, but that's what at least my understanding is that it is. Anybody?
Yeah, so I kind of want to shift the discussion a little bit towards more of like the interpretive questions rather than the systems questions. So just to throw something out there, does the move towards smart contract, or this sort of like hybridization of formal language and natural language, does it sort of widen the gulf between intention expression, which is also inherent in natural language contracts, and is it a difference in degree, or is it a difference in kind? And sort of how can we think about this, and what sets of institutions would we need to sort of define paying attention for smart contracts, and are they different than the institutions that we have with our traditional contract clauses? Yeah.
Somebody else wants to say something.
Oh, I mean, I guess I kind of said it already. I think that it's a matter of degree, because if you look at this concept of intentions, it's a really capacious concept. And you think about how intention, this term, is used in various areas of the law, like constitutional interpretation, statutory interpretation. If you really think about how intention is used, it's often largely constructed. If you think about, say, legislative intentions, well, kind of the core aspect of legislative intention is constructed in the sense that courts say all the time, they assume that the legislature intends the ordinary meaning of the language, right? That's constructed. And it is probably false in a lot of cases. Another example, courts assume that legislatures, if they have a certain phrase in one statute and a slightly different phrase in another statute, courts assume that they have a different intention with respect to the two statutes, which is constructed. It could well be false. And so it kind of goes back to this. I think intention is a spectrum. And on one side of it, kind of the closest we can ever get to real subjective intentions is these face-to-face interactions. But even with that, it's constructed. Just think about any kind of relationship you've ever had, any kind of conversation you've ever had, right? You're trying to make inferences based on what the other person is saying. But even those inferences you're making are constructed based on other conversations you have, based on what you think words mean and semantics.
So, do you think the problems of intention within smart contracting come from this clash of communities between maybe lawyers who are like sort of steeped in the paradigm of legal contracting and sort of the more like technically proficient people who have different ideas of contracting and how we define intention from? Do you think like this whole sort of difficulty is sort of like the different contexts that come with different communities who are interacting together?
Quite possibly. Probably Josh is a better person because I have no idea what the tech people are doing. But I would think it's an empirical question, and I would also, because it kind of goes to Jillian's point too. We need to have institutions or courts capable of kind of deciphering what's going on and thinking about, are they capable of thinking about intent with respect to these smart contracts in an intelligent way? Maybe there's a role for an agency that has expertise that can provide regulations. So there's kind of the legal authorities, there's the makers of the smart contracts, but I'd also think we need empirical work done on people who enter into the smart contracts because they're stakeholders also. What do they think they're entering into? What do they think these contracts mean? Do they think because I think consumers think when they enter into a contract of adhesion, they're not really bothered by it in the sense that they should be bothered by it if they're actually bound by all the terms. But they think that courts are going to act as intermediaries, and through various doctrines on conscionability, consumers think they're protected as well as courts. Is that true with smart contracts? Or is it really a situation where people enter into smart contracts just accepting that there might be a cost benefit, and there's a cost to entering into the smart contract, which is you don't have this protection of law, and maybe they're willing to accept that cost. I can't imagine that's the case, but I don't know.
But then briefly, I think we can render concrete this question, like what do people think? So many people buy non-fungible tokens or cryptocurrency for the reason that they want to capture its rising value. One of the common license terms that comes along if you buy one of these incredibly expensive non-fungible tokens is that you don't capture the rising value. For example, the Nifty license, which is an IP license that comes along with many NFTs that are purchased, caps you, says above, I think it's something like $10,000, above $10,000 of value, you have to come back to us and engage in another sort of licensing deal in order to capture more value from the rising value. So even the most basic concept of I bought it, it's mine, ownership means I capture the rise in value as an investment, even that is routinely undermined by legal terms that are adjacent to or buried in this computerized contracting process through smart contracts. I do think that we need empirical research on what people think they're buying when they buy an NFT. Somebody paid $69 million for people's first 5,000 days. And if you pop the hood, and I've gone to conference after conference where people assert, they say, when you buy an NFT, all you're buying is a record entry in the artist's sort of book of people who like the artist. That's not what people think they're buying when they buy these things. Constructed intention, I do agree. And really the question is, how far down into code will we construct humans' intentions to go? Do we construct their intentions to be whatever the machine does? Because we can say that, like, it's the equivalent of sort of gambling. We know there's bugs in code. I'm just going to take a bet that there won't be a bug. The difficulty with that is, as the security of an iPhone shows you, there is always a bug. It's just a matter of like how long it takes. There's a certainty of it. So the idea that like I choose to transact in the face of an absolute certainty of exploitation seems to me
in this way, you see that as distinct from natural language contracts. Like the bugs are inherently there in a way that like loopholes are not as prevalent in traditional contracts.
Yeah, I do. I think courts or any other natural language community, I'm a fan of courts because of some other social features that they have, but any natural language community can take a look at this and say, I'm looking at the code, I'm looking at what you said, and I can decide, yes, I have to construct it, but I'm going to construct a sense of what the people thought was the gainful trade here, what they thought was going to be beneficial to everybody involved. And sometimes they're wrong and sometimes they're right, but they can do that in a way that a formally coded system, in my view, can't. And that you're inevitably going to have to ask, as my friends in Melbourne did, you're going to have to ask a judge what to do about the person who's speeding through. Natural language, here's the reason why. Formal languages are consistent, but not complete. There are certain statements that a formal language system cannot say that are true. Natural language is complete, but not consistent. And so natural language can always express, even if it is contradictory, can say, I know what happened, but it is our estimation that that is not what the community intended. You see this all the time when a blockchain, for example, has a bug in it, somebody starts manufacturing piles of extra cryptocurrency, dilutes everybody else's value, dilutes everybody else's interest, and a community of people come together and say, that I know what the code did. That's not what we intended. As a community, we're going to come together and fork it. And
okay, I'm shaking my head.
yeah, go on, shake your head. So,
okay, so no, natural language is inevitably incomplete. Natural language contracts are inevitably incomplete. I think and they're incomplete, especially if you start thinking about what you're thinking about with a smart contract, which is the enforcement mechanism, and how will they be interpreted and how will they be executed, and what kinds of conditions might arise, what processes will be used to determine whether or not we execute on this contract. That's exactly the same in natural language contracts. You're going to, first of all, the vast majority of people who write a contract have zero access to any kind of adjudication to resolve a dispute. And oh my gosh, they discovered that. They said, wait a second, my contract says this. They say, yeah, it's going to cost you $350 an hour to get anybody to do anything about that. And you have courts that are biased, that are not paying attention, that are not available. I think a really important thing to remember, and I don't intend to be here as a rah-rah, let's just let the tech crypto community go wild, because I'm not at all taking that position. I'm just, sort of theoretically, is there something really different here that, as you're putting it, code is incomplete, natural language is incomplete. Yes, true, especially if you think about the institutions. And smart contract or crypto world is responding to is the failure of our legal institutions in lots and lots of dimensions. You know, the large part, the difficulty of contracting across jurisdictional boundaries, the absence of reliable, non-corrupt courts in huge parts of the world, the inability to write a contract with somebody who's providing you with goods in another part of the world that doesn't have access to courts. And they would like to be part of the international trading framework, and executing a deal on blockchain is one way to do that. So we absolutely need institutions. You can write provision in code into your contract that says there will be an exception for commercial and practicability. You just have to write the code that says it's going to kick it over to some organization that's going to decide that. But anyway, so yeah, natural language is not complete.
Just to correct, I think we're saying exactly the same thing. I never said that natural language contracts are complete. I said that the gap-filling mechanism must include natural language because natural language is complete, which is exactly what you said. You can have commercial and practicability as long as you ask a natural language community to consider which are the provisions, the non-occurrence of which is a basic assumption of the parties to the contract. What you can't do is code that. You can code the kick-out to a natural language community. But the opposite is not true. You can code some regular rules of the road enforcement provisions, and everything that was said about the cost of courts and the ease of enforceability and the need to lower costs is true. For many of these provisions, you can encode simple escrow, or you can encode for things that happen all the time, you can code outcomes. But you can't code all outcomes, and you have to kick it out to a natural language organization. Exactly what you said. You cannot solely keep it as a matter of structural code because there will inevitably arise conditions that the code can't handle. That's just a feature of code, especially of, in this context, decentralized code, where you've got code that is interacting and creating emergent consequences between them, which is exactly what happened with the DAO, right? They had their own code. It ran up against other code. There were resonances between the two sets of code. Never mind the fact that the second set of code was coded to exploit the weaknesses of the first, right? When that happens, you're inevitably going to have code that doesn't do what anybody says. So I agree with everything on the cheapness, on the failure of institutions. I think, though, what we've got to hold on to is that we're still focused on human, or at least my view is we're still focused on human intentions and human well-being as the goal of contract law. And we have to have natural language interpretation, natural language construction at the end of the day, because code cannot do that in all cases. That's an indelible feature of mathematics.
Great. How about we open it up to the audience for a few questions?
So, what about, so code as declarative logical expression? Yes, you can't write a set of rules that there's going to be an if-then that's not in the list. Yeah. But there is a world in which I can train an algorithm to understand. I could train my wallet by spending enough time to understand the stuff I care about. And or in a community, you could train contract witness to, so it actually infers something that wasn't on the list of if that. Right? So I think part of the way you're describing it is kind of restricting it to declarative software, and mostly what you described is also me as a regular person interacting with that, right? So I'm looking at a screen and finally clicking yes. But there's a world in which I can program my wallet to not engage in contractual behavior that I wouldn't go for. Right? So I think there is a next layer out there.
Absolutely. I think that, and then a response sort of further deeper down, but that's the problem. And maybe that's the solution. It's this hybridized using a neural net, training a neural net on millions of our responses, and then saying people like me do X. And we can get neural nets that begin to give us good, almost human-like responses. To that, there's sort of one formal answer, which is sure, but it's still not going to replicate unobserved behavior. And when it does replicate unobserved behavior, its emergent characteristics are fundamentally not human by definition. So there's no getting away from that fork. The second bit is, yes, this is great, but I maintain that we have a very weird world we're dealing with now, where Amazon's hegemony is threatened, and we're seeing case law sort of edging around the edges of this. What happens when your neural net contracts with their neural net and does the idea that Amazon always wins, or that Amazon can force you into a dispute resolution mechanism based on either a line of code or a statement of natural language to which your code did not respond or was not trained to respond? I think we're just beginning to touch the edges of that. I have fears about how that will turn out, and I think the cases are already beginning to trend in that direction. I'd like to stop that shit before it makes that turn deeper into the claim that power asymmetries will be replicated when my smart contract interacts with your smart contract. But that's also the narrow scope for optimism, which is maybe if we took this seriously in some kind of battle of the forms way, maybe we would say my neural net has every much of a set of rights to assert my right to go to court, as your neural net has the rights to say, I'm going to force you into arbitration where there's a gigantic flushing noise and nobody ever hears every case again, which is what happens now.
Or Amazon might have to operate in an environment where there's a lot of people like Gillian, so nobody's going to buy anything unless.
Or more likely, they'll just simply refuse your neural net unless it agrees to their terms.
Right, but if there's enough, right? If it's not my personal neural net, right? But
yeah,
I've decided to be a new form of boomer, you know, and all of us boomers are adopting that neural net. And all of a sudden we realize you don't sell the boomers if those are your terms.
That would be my hope, and that was the slip. That was the space for optimism I had. Yeah.
Let's go to Corey.
Just wanted to go back to the beginning of the presentation where you talked about intentions, and you mentioned the example of the 3,000 versus 300,000 difference. How do you know the intentions? And let's talk about specifically around like prices. And then what is the parallel to, you know, you go into a store and they put the decimal in the wrong place and you get to pay the price that's listed. Yeah, so can you just, this is a whole new area for me, but that kind of stuck out as, how do you know what the intentions are in these types of situations?
It's complicated, but you ask whether or not the other party knew or should have known the context that this was improperly priced.
How would they know that NFT?
I had a student at Indiana who made a thing of price sniping typo mistakes by airlines. And they let him get away with it for a while. And then they said, you know or should have known we were making a mistake. No, we are not honoring that price. That's a perfectly coherent sentence in natural language to say. And that's where courts are, in my view, going to go with it. As to why you would know, one easy way of demonstrating it is that the purchasing smart contract would have a bid range. It's going to know what the things have gone for in the past. And the reason that it sniped it is the difference between its past sales price and its present listing price. And so it's just automatically going to buy it based on that differential.
Can I just follow up? Because this is, I mean, it's such a new area. So an NFT has, I mean, no inherent value, right? It's, I mean, a lot of things don't have inherent value, fair enough. But so you're buying this piece of artwork and you're like, oh, I meant to say it was 300,000. I bought it for 300. But like, how was that conveyed that like that was a mistake, since this is so brand new that there isn't?
You would have a trading history of it, the same way your house has value, right? Value is a consensual hallucination.
Yeah.
And the way we track the consensual hallucination of value is we just look at past trades.
But sorry, so doesn't that assume that the value then could never go down? Like, what if Because because this is so new and there is this collective delusion. At some point, people might wake up and be like, "This is all BS. Why are we paying $300,000 for an NFT?"
Absolutely. And if there were a crash like that across the board, you would expect a human court of natural language to say, "Oh, the context is, as a general rule, people have gotten over the art NFT market. They're now not worth anything anymore, just like tulips or houses in Vancouver or anything else that's subject to these valuation questions." And a broader context makes it clear these things are crashing to zero, and you're buying them the way you might choose to buy stock in a company that's crashed just on like maybe the chance that it would bounce a bit. And that is a different context from these things have been holding their value, generally speaking. This thing has been trading at about this price, and suddenly it goes for 100th of its value. And a natural language court, or even a natural language group of humans like us, can tell the difference between those two narratives and say one of them is reason to say you knew or should have known that there was a typo involved, and the other is to say, no, this is just a person buying a penny stock.
I'll just add, but it just goes back to constructive intentions. And how do we know that an electronics store is not selling a TV worth $3,000 for $30 because that's their business decision? It's just based on world knowledge that the court assumes everyone shares about the worth of things and about rational human behavior. But maybe those kinds of inferences are more difficult, which seems to be what you're suggesting, right? Which could well be true. Maybe the more difficult with smart contracts and some types of smart contracts. But I think the process of reasoning is the same within smart contracts and outside of it.
Eileen?
Okay, so much of the scholarly communities have been invested for at least 3 years. Smart, they've been saying we're not going to let the bros tell us this is important. We actually don't think it's important. It's not very effective. And so all of that is my lead in to say, why not recharacterize the masochism as let people have what they're signing up for? In this way, we don't let this stuff get into the court system. And maybe that would naturally cap the value of the US dollar, whatever, actual currency amount is going into this. And it's good, like, you go gamble it as long as we're not some addict, we're not really worried, like, these are small amounts, go for it. And so if you want to run like this sort of low value smart contracts and know that you're taking the risk, then what's the problem with it?
Yeah, I think it's because of what Gillian was saying about the value of these institutions. I think for handling many cases, they're extraordinarily valuable, and I don't think that they will remain low value. I think that there's every chance that routinely hundreds of millions of dollars will flow through these things. And I think it is therefore inevitable that humans will assert the claim something different happened than what everybody in the world thought. And
Yeah. But I'm back to kind of again this conflation between, so you can say, okay, we can think of lots of cases where if you participate in this institution, you are buying into all kinds of ways in which it works, probably lots of which you don't know about. If you write a will, you go to legals and write a will, it's got lots of stuff in there that's specialized language that you probably don't really understand. Now, if legals have done their job well, they gave you a smart interview and you did get what you want, but nonetheless, you've got this thing that's a specialized system. You don't know a lot of what you're going to get out of it. And then you're actually putting into a mechanism that doesn't work in theory. It works in practice, which in practice maybe you can't afford to litigate the will. There's all kinds of things. So I think but I feel like that's a conflation here. And then, and what worries me is it's kind of scooting off the clean question of why can't we have systems that people create? It's not masochistic for people who enter into some of these settings to say, okay, I decided to trade NFTs. That's the way they work. And yeah, there's going to be stuff in the code. And, there's some people who argue that's how we should interpret the very simple contract, that we shouldn't have a doctrine of commercial practicability, right? There's a long history of law and economics writing that says, if it says you're selling that aluminum at this price, right, you don't get to claim. But, crazy stuff happened and the prices went argue that. So there's a difference between saying the clean question of why can't we contract in these ways, in these different institutions, and there's power, there's inequality, there's stuff that gets embedded. That's true, and that's also true in spades in the natural language level. So I feel like I feel a little bit like we're switching the argument from should we have a separate set of institutions? Should we enforce these things with a different set of rules? And well, there's in practice, there's all this, shenanigans going on embedded in it now. Okay, that's a different argument. That's a different argument, and that's happening all over the place. Natural language science.
I have a quick remark and a question. Let's start with a remark. The European Law Institute, that's the European equivalent to the American Law Institute, just started a new project on automated decision-making in contracting. And what we're doing there is we're doing a sort of ADM readiness check of EU consumer law. This was initiated by the European Commission, and they asked us to do this because they want to assess whether existing EU consumer law is ready for a scenario where consumers are delegating contracting decisions to their smart assistants, in a sense, like you discussed this. Do the rules have to be rewritten, or can they apply to such a scenario? So the work just started, maybe can contribute to this conversation in a few months or in a year or so. And another question, and that relates to the idea of a licensing system that I think you, Gillian, mentioned in the first half of the debate. I understand that would involve smart contracts only being binding if they comply with licensing requirements, for example, having a line of code on a dispute resolution system. How would you enforce such a system? How do you ensure that only, because if the smart contracts are self-enforcing, how do you make sure that a smart contract that does not comply with this requirement does not, is not being enforced in an automated sense? A related question would be if you want to make sure that smart contracts are only let's say, self-enforcing when they comply with consumer law, for example. How do you ensure this?
So I think this is the point that you're building regulatory systems around. So so the idea of licensing is to say, at some point there are some humans behind these institutions, right? Creating, developing the blockchain, developing the systems, and so on, offering the smart contract. And if you say we have a regulatory regime that says you can't engage in this kind of activity, it's unauthorized smart contracting, right? Unless you maybe have an insurance pot to pay out claims, unless you have dispute resolution procedures and so on. So that's regulating humans and their behavior. And how do we do anything like that? How do we enforce? Let's spend a lot of time working against our unauthorized practice of law rules. Right? We go after people who are engaged in that, including organizations that engage in that. You can be thinking criminal law, you can be thinking administrative fines, you can be thinking, access to other assets, physical world assets. This is not to say there wouldn't be ways around the same thing as, banks are not supposed to lend people that they haven't gotten, know your customer disclosures.
But that would be public enforcement, right? There would not be like a private enforcement.
Yes, so I'm certainly not conceptualizing that as public enforcement. Yes, the regulation around this, right? I'm thinking about that. Can I say something about the automated adjudication piece? You guys have time? Because this actually I do spend a lot of time thinking about. Smart contracts a little less so, but thinking about. So this is maybe going to the point you need to go to natural language to resolve disputes. And of course, we are thinking about how do we build. Because we actually have so little access to human decision making, are there ways we could build automated decision making that actually would get us closer to And I think the questions there are around, you know, the questions of how do you train such systems, the machine learning questions, and maybe it's beyond sort of our current systems of machine learning. But it's a question of how do you build those systems? And, you know, we're only this far into the question right now, so European law with rights to explanation is something which really doesn't make any sense. Or we train systems on past decisions, and oops, our past systems are biased, our past systems are racist. Or, you know, we've been trained, and it's like, who would have thought that was the way to train a system to implement legal rules? And we know we need something other than trying to hard code those rules in an expert system. So it's a real it's a frontier challenge for how to do that. And governments and agencies and individuals around companies around the world are now trying to figure out how to build. It's tremendously important, I think, challenge. But it does come back to, you know, again, when you choose to contract with a particular system, you're choosing its dispute resolution mechanism. And it's not a theory thing, it's an actual system. It works in particular ways, and some will be better, and some will be worse. And maybe there's an automated system that's resolved.
All right, I think we have reached time. Just join me in thanking our panelists. Before we move to the final session of the day.
Your job.
So